Well, just days after Derek Chauvin's conviction for murdering George Floyd, we're getting questions about a potential appeal as claims are popping up online. Our National Verify investigator Gabe Cohen explains the process and how it could play out.
As Derek Chauvin awaits his sentence, there's a lot of talk online about a potential appeal. One viewer asked, could Chauvin's case be overturned because of pressure on the jury? Let's verify. Can Chauvin appeal his conviction? And how could that play out? Our sources, Court Footage and Rules, the National Post-Conviction Project, and 3 legal experts. The Minnesota judicial system has 3 levels: District Court, the Court of Appeals, and the State Supreme Court. Chauvin was convicted in District Court. Now he'll almost certainly file with the Court of Appeals. He has 90 days to do that. There, he's entitled to have a panel of 3 judges review the appeal. Chauvin could ask for a range of remedies, from a complete acquittal to a lesser sentence. But our experts say most likely he'll want a mistrial, and he'll have to list his reasons.
The biggest argument will just be that he was denied his constitutional right to an impartial jury.
The jury was partially sequestered during trial, supervised at the courthouse, but free to go home at night. During that time, the city of Minneapolis reached a $27 million settlement with George Floyd's family. Dante Wright was killed by police, sparking protests, and politicians weighed in on the trial, like Representative Maxine Waters, who said if the verdict isn't guilty on all charges, protesters should get more confrontational. Judge Cahill had this response.
I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned.
So is that enough to win an appeal?
I think that was a little bit of an offhand remark.
That's law professor Ted Samsel-Jones.
It's very unlikely that that's going to result in an actually successful appeal.
You would need evidence from a juror or jurors that they heard the statement and that it impacted their decision.
Rachel Moran was an appellate attorney for 5 years and says all of that publicity is not enough to prove the jury was tainted.
Without evidence that it impacted the jury's verdict, you're kind of just shouting into the void.
That could change if any jurors speak publicly and indicate that something off limits came up during deliberation or swayed their verdict.
If a juror says, hey, without a doubt, I was going to find him guilty.
Lee Hutton is a national trial attorney.
That could possibly lend the defense an opportunity to declare a mistrial.
Chauvin's appeal will likely cite other issues his attorney raised during trial, like some of the jury instructions or the prosecution's closing argument, which they say belittled the defense, or even something we don't know about that was discussed during a private sidebar.
I anticipate there's probably going to be 5 or 7 very critical issues to discuss.
But as of now, none of our experts think an appeal would succeed.
I would be very surprised if the Court of Appeals disturbs the verdict.
I don't see it being likely.
He's got valid, non-frivolous claims to appeal, but that's very different from saying that he's going to win.
The National Post-Conviction Project, a nonprofit, found 90% of appeals in the U.S. are denied.
The Court of Appeals is very hesitant to disturb the finding of a jury.
Courts love what they call finality, which is the verdict was rendered, let's leave it at that.
If Chauvin loses his appeal, he could go one step further and ask the state Supreme Court to review the case. But unlike the appellate court, they don't have to.
Will Chauvin stay in prison during the appeal?
Yes, he will.
So we can verify, yes, Chauvin can appeal his conviction. But our experts say, as of now, it's unlikely he'll get a mistrial. With your Verify, I'm Gabe Cohen.